Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
This is a fascinating moment. When a defendant says, I just want to do my time, that usually signals probation fatigue. Probation sounds easier than jail, but it's structured, monitored, and demanding. Drug testing, sponsors, treatment, travel restrictions. For some people, the constant supervision feels harder than serving a short sentence. But here's the problem. Once the judge takes control, the deal on the table disappears. Would you risk that gamble? And that's the shift. The state's prior offer? Gone. Once negotiated.
Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor.
I have something, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
Okay, thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Stack the violations together. Failed groups positive test sponsor manipulation leaving the state. Each one alone might be survivable. Together, they paint a pattern. Judges look for compliance trends. And this trend says supervision wasn't working to this point. What outcome do you honestly expect? And there it is. 180 days, the maximum for many Class A.
Sir?
She doesn't want that, right? I mean, it says right here, she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which the, what do you want?
If I can do the 60 days that they offer me and be off probation.
Well, 60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today,
Yeah,
so.
okay, so
What-
I'll have to be reinstated.
Okay,
It is a misdemeanor, Your Honor.
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the, maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with
Okay,
obviously things that can be dealt with. through therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't.
Right away, this isn't just a routine check-in. A pre-sentence report in a revocation hearing is critical. It outlines compliance, violations, treatment progress, and risk factors. And when someone is already on probation for a terroristic threat against a public servant, the margin for error extremely thin. This report is about to decide whether she keeps freedom or loses it.
Yeah, I'd actually revoke her.
so, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can I get my phone and my system?
Talk to the bailiff. Just talk to the bailiff.
I need to.
Yeah.